Hey there, Max here, and we're going to be watching a little bit of Legal Mindset, one that I think is a curious offer here. It's about Nintendo loses a big patent battle, and I do believe this is about how they went at Palworld for using Pokeball-like things to capture and summon little guy, basically little monsters and minions and such. If that's the case, that is great to hear because I think that was a BS patent to take over because that could apply to so many things, honestly, and not just Power World. So that was just such an overreach, in my opinion. And not to mention, there's a bigger target right now, I believe, that was recently came out. But let's go ahead and take a look and see what the fast facts say. Legal Mindset, we'll take it away now. I will leave a link to the original in the description. If you enjoy, please leave a like. If you have anything you'd like me to react towards, please leave it in the comments. And please subscribe to follow along with me in the future and help me build my community. Let's get it going.
Nintendo has been absolutely wrecked as one of their patents is blown away, and this is going to set them back in their battle with Pocket Pair and Palworld. We're going to get that today on the Legal Mindset, where we teach you to be your own judge. I'm Andrew Esquire, American attorney. This is a Fast Facts video, the quick and dirty version of the latest in legal news.
You know, when it comes to lawsuits, I believe Nintendo and Disney are two that I would really like seeing to lose some lawsuits for once.
So jumping right into it, our defendants today are Nintendo, the big global game company, as well as Pokemon Company and the Pokemon Company International. They have been in a very pitched legal battle with, of course, Palworld and Pocket Pair, but now they're getting blown away by the U.S. Patent and Trademark Office, the USPTO, which has now destroyed one of their patents. We're going to get into that. So
I wonder how many other patents they tried to make. I know they tried doing a few. I think one was also for being able to ride on some monsters, which I think Ark would have a few things to say about that. But
as some background for those that may not know, Pokemon has been, and Nintendo have been very, very, very mad at Pocket Pair and Palworld for a while now. And because of that, they engaged in lawfare by suing them for patent infringement in a Japanese court, that's the Tokyo District Court, since September of 2024. Now, as that lawsuit was ongoing, a year after that, in September of 2025, the U.S. Patent and Trademark Office granted Nintendo a patent covering a very, very broad topic, which was summoning a sub-character and having it battle on the player's behalf.
There are so many games that do that. In fact, Square Enix is probably going to say something about that because summonings, that's literally a whole thing from there. Oh, and Beastmasters is a class that would have had that as well from like tactics. There's a whole bunch of things that use that particular system. It's way too vague of a thing.
Inclusive of the ability to switch between manual and automatic battle modes. So this was a very, very broad patent, and at the time, Nintendo had been pushing several overly broad patents into both Japan and America, and people have been speaking up about this, saying, hey, wait a second, this covers a lot of things. And at the time, people pointed out other games like Persona, Pikmin, World of Warcraft, Diablo, Borderlands, Disgaea. There's a lot of other
Really? Not Square Enix at all?
games that use this same mechanic, and it seems to be problematic, saying, hey, so many games.
I remember definitely Final Fantasy X for sure used that, where you actually could summon a monster and then control them.
Games are using this mechanic. How in the world are they coming up in 2025 all of a sudden patenting this when this is something that has been used before? Well, a very interesting note here is when you're looking at these patent reviews, you're looking at what patents have been filed before, not just the actual games. In fact, the people reviewing it may not actually have played any of the games we just mentioned. However, what we did have was the actual U.S. Patent and Trade Directive.
I have a funny feeling that a lot of the people who do acceptance of these patents don't play a lot of video games, I would assume.
in November of 2025, just 2 months after that patent was issued, saying, hey, wait a minute, we need to re-examine this Nintendo patent that was granted. And that's very much due to everybody calling this out, people saying, wait a second, how did this get approved in the first place? And this is only the second time in a decade in which a director ordered a patent to be re-examined. And they cited prior art as the reason why they were saying, hey, wait,
I mean, that's pretty darn obvious.
look at this again. They're saying that prior art was pretty much describing the same idea. So they looked through existing patents that are in the US patent system already. And those included a Konami 2002 patent named Yabe. And these are, of course, often named after the people that create them. Then Nintendo filed their very own 2020 Taura patent. And then Bandai Namco had a Shimamoto patent. And then, of course, the last one they looked at was Nintendo's 2022 Motokura patent. So when they looked at all of those patents together, they said as a whole, actually,
Interesting that they actually pulled a Nintendo patent against another of Nintendo's patents.
include everything that was in that new patent that they wanted to get granted in September of 2025. Essentially, there's nothing new here. Everything has been covered by past patents, so there's nothing new. It's all inclusive in those previous patents. Therefore, your patent is invalid. So on April 2nd, just a day ago, the U.S. Patent Office issued a
Ooh, they did like 26 claims? Dang.
non-final rejection.
Ooh, 2 months to appeal. That's not a lot of time when it comes to law. And honestly, I don't think there's anything that they could possibly say or do that's going to make it any better.
Of all 26 claims in the Nintendo patent. So saying, hey, all of those, they're rejected. Now, they are able to appeal that. They do have an appeal right. But they said that the invention, this patent, was obvious in the light of prior art. And they said that, hey, it's invalid as a whole because of these previous filings. Now, they've got 2 months to appeal, and they have the possibility of some extensions there. And they've got some arguments on their side to be able to try to come back and try to resurrect maybe some parts of that patent. But that's up to Nintendo's team of lawyers. Now, how does this affect Pokemon versus Palworld?
Ooh, that's actually a nice art.
Well, this is a very interesting question because actually there is no direct legal effect. So the US patent does not affect the Japanese patent. They're separate.
Probably the best they could possibly say is like an example of was dissenting opinion. But if it's Japan, it'll only affect Japan ultimately.
Systems, the US patent system, the Japanese patent system. So the Japanese case is citing the
Okay, yep, these are the things. That's the one I was talking about, the riding and mounting. And that is so dumb because World does that darn thing as well. You can ride and mount monsters in there, aka dinosaurs. But there's a whole bunch of things that can let you do that. That's silly.
Japanese patents, which are still in place.
I don't know how that's going to affect a lot of other things that already exist.
And as a reminder, those patents involve creature capturing, throwing, summoning for battle, and riding and mounting, which includes flying. And the Japanese Patent Office is applying that Japanese law and saying, okay, this is Japan. And I want to make a little quick comment. This is a fun time for a Justice Jackson comment when she commented in the Supreme Court just the other day that stealing a wallet might make you Japanese. No, that doesn't actually work out. And neither.
What? Where did this come from?
Does applying the law of one country to another. So we have to keep Japan separate. Sorry, Justice Jackson, you are not in fact Japanese. But let's jump over and continue. So the good thing for Palworld is that this actually, while it doesn't have a direct legal effect, actually affects the validity of the validity of the other patents in terms of arguing they are invalid. So it strengthens the argument that other Nintendo and Pokemon patents may actually be invalid. And we at this point have a US rejection, but also Japan looking at patents and saying, no, they're not okay. Japan already rejected one Nintendo Pokemon patent on similar grounds, saying there's similar art, right? This art already exists, so we're going to reject this patent. So this could become a pattern for Nintendo where they're having their patents that they submit.
If they really wanted these things patented and harder, then they should have done it a long time ago before it became such a common thing.
more closely scrutinized,
And thank God they didn't, because the gaming world would be a lot worse for it.
maybe even re-examined in Japan. That's always possible. So you might have a situation in which they're losing ground in terms of their patent applications. Also, their whole US strategy has been crippled. So the Nintendo's US strategy, along with the Pokemon Company, was to essentially file a bunch of patents as an anti-Palworld protection. So essentially trying to prevent Palworld and Pocket Pair or other companies that want to do something similar to Palworld or Pocket Pair from being able to do that in the US market. And now that they've been blown back on this, it looks like that whole strategy of trying to panic file in the US and cover everything is not going to work. And that also has reduced the chilling effect on games. Developers that want to have Pokemon Palworld like games or games that may have some sort of similar feel or theme are not edged out of that entire genre of the.
And not only that, but there's like games that might even use similar functions, but even isn't even the main function. Even if it is slightly similar, they could come after him for it, and that could get rid of some mini game kind of levels of things as well too, if that's possible.
Monster catching genre. It's not all dominated by Pokemon. You don't have to bend the knee to them before you're able to enter that space. So that chilling effect on game creation has been reduced. And I think this is a massive win for Palworld in terms of PR, because if you think about it, they're now able to have the negotiating leverage of saying, okay, you're not going to be able to box us out with patents outside of the lawsuit, because they're able to say, if they were able to, let's say, corner them by saying effectively, hey, we're patented out the US market, Palworld, you're not going to be able to enter that, other companies won't be able to enter that, then the settlement in their Japanese lawsuit might be less, right? Because they're able to say, hey, you don't have any market to expand, you can't take this game anywhere. But now they can't do that. They can't box
Big case destruction
them out. They can't prevent them through these other strategies, and therefore they may have to come to the bargaining table or offer more, or
Ooh, and can we even mention Digimon for one thing?
come to some sort of settlement arrangement with Palworld. So here's my judgment. Nintendo losing this patent is certainly a significant setback in its global plans. And the bigger thing is Pokemon's lawfare campaign is failing. It is not working out the way they thought it would. They thought they'd be able to bully them into
Honestly, all it really did is make people hate Pokemon a lot more.
submission and just submit mass filings that would just be rubber stamped. That's not going to work anymore, it looks like. This is an indirect
Not that it really affected anything like their market share or anything, but it definitely did leave a little bit of a foul taste in the mouths of people who were following this.
win for Palworld, and it further inspires them to
I mean, I know I haven't bought a Pokemon game since Sword and Shield, actually.
fight rather than to fold and cave to Nintendo. But I want to know what you guys think about this, and I'll catch you in the comments below. Bye.
All right. So I'd say that's some good news for Palworld there, and in gaming in general, that Pokemon couldn't be able to patent the whole minion summoning thing, and I hope there's a lot more of those things that got thrown out. I still can't believe that they patented riding a creature. That's gotta be one of the dumbest ones, honestly. That just feels like they're just throwing spaghetti at the wall to see what sticks, and I'm just glad to hear that very little of it is. But yeah, well, tell me what you think in the comments about what you think is going on with that here. And please do leave a like if you enjoyed this anyway. Please leave any comments of anything else you'd like me to react towards if you like. And please do subscribe to help me build my community and follow along more in the future. I'd thank you very much for watching, and be sure to live life to the max. I'm out.